Welcome to the LS Carlson Law Podcast. I'm the new host, Kirk Pearson, and I'm here with my colleague, Vasco Alexander. Welcome, Vasco.
How are you, Kirk?
Doing well. Why don't you tell me a little bit about your background? Where did you go to school?
Sure. I went to Cal Western for law school. Prior to that, I'm an anteater, UCI, 2006. Very proud of that. But San Diego was an awesome time to go to law school and learn the craft at the beginning.
Yeah, UCI is a great school with such a terrible mascot.
Hey, the anteaters, Zot.
Yeah, excellent. Tell me a little bit about your background. You're part of the litigation team here at the firm.
That's right.
Tell me a little bit about your prior experience as it pertains to litigation.
Sure. I've been a litigator my entire career. Starting off, I started with the Port of San Diego, actually, which is going to transition to what we're going to talk about later here. But I started my career like a lot of lawyers in Southern California, and that's with construction litigation. And I did that for a little while until I got into commercial litigation representing freight forwarders and warehousemen and folks in the logistics center with litigation needs. So, yeah, I've been a litigator for about 12, 13 years and enjoying every minute of it for the most part. But like anything else, we have our ups and downs, and we're going to discuss some of these that I'm seeing down the pipe. There might be downs for warehousemen as part of this podcast.
Yeah, and so you kind of handle all the types of litigation we do at the firm. You know, we do kind of a broad range of real estate and business type litigation here. But more specifically today, we're going to talk about kind of your niche area of interest as it pertains to litigation. Can you talk a little bit about that?
Yeah, so the big umbrella is commercial litigation, right? And I like to think of myself as a bit of a janitor when it comes to it. We're either cleaning up a mess or ideally trying to keep the mess from being made. And that's on the front end with the contractual negotiations in terms and so forth. But on the back end, when the carrot doesn't work, we come in with a stick. And we enforce contractual rights. So whether we are on the plaintiff side chasing down money, essentially, at the end of the day, or on the defense side trying to prevent that from happening to us or minimizing the risk, that's what we do. That's what I do. And the niche that you're addressing is this logistics sector, which is anywhere from freight forwarders all the way to warehousemen, the manufacturing process. Those are commercial contractual relationships. And for the most part, if you're a business litigator like you are as well, Kirk, you know the typical causes of action, which you might experience: breach of contract, fraud. We address those things. But there are specific niche nuances that pertain to those sectors that a lot of litigators are not aware of. And especially when they're dealing with advising those kind of clients, I think it's important to have that insider knowledge and be able to provide a service beyond just you go to court and you litigate.
Yeah, and just for the listeners who might not be in the industry, when you're talking about warehousemen, can you elaborate or be more specific about what you're talking about?
Oh, sure. Yeah, that's anybody who is storing goods for somebody else. And it could be your typical mom and pop warehouse where you go and you store your personal belongings, all the way up to an Amazon warehouse that is taking in goods from all around the world. So the warehousemen vary in size, vary in complexity in their operations, and they vary in their ability to service. And as you could appreciate, and anybody else listening to this, California is a hub for that. Why? Because we have the Port of LA and the Port of Long Beach right in our backyard. It is unavoidable that those kind of commercial issues are going to rise in California, the same way that we have the Hollywood industry and of course, a lot of construction here as well.
Yeah, most of us that live in Southern California are pretty familiar with, the ports, but then also in, Riverside County, other areas of the Inland Empire. there's huge, warehouse areas, and that includes everybody from like the big dogs like Amazon all the way down to, I would assume you're also referring to people that, for example, store furniture while somebody's having remodeling done, things like that.
Absolutely. Yeah. Yeah. The sizes vary from, 50 square feet all the way to 1 million square feet and up. And it's interesting you mentioned the Inland Empire, because that might be a bit of a segue actually to the topic today. And the reason I'm bringing up the Inland Empire is because of what you just mentioned, which is these giant warehouses being constructed and built out in the desert. But before we dive into that, I think it's important to have a little bit of historical context of where we are today with warehousing in California.
Yeah, what are some particular issues that we're kind of facing or dealing with now?
So the reason I wanted to talk to you today is because I think there's a perfect storm brewing in shortage of warehouses coming in California. And that perfect storm is coming in the heels of another perfect storm that happened. And we have to jump into the time machine a little bit to the pandemic. Anybody in the industry...
When you're saying the industry, you mean anybody that's in the warehousing industry?
Yeah, in the warehousing industry and the logistics. This impacts freight forwarders as well, but specifically warehousemen. So anybody in that industry remembers there was a warehousing shortage at the heels of the pandemic. Everybody's working from home. There's a lot of orders coming in, shortage of workers, an influx of goods coming in. And if you were living on the coast or visiting the coast, you would see the lineup of ships going all the way out to the horizon.
Because we were all buying gym equipment and home office furniture and all the, we were bored, so we were buying a lot of stuff. Yeah,
that's exactly right. And that created a shortage in warehousing space. And at that point, a lot of warehousemen got caught off guard a little bit. They needed to empty out their space, but were not able to because of this glut that came in. A lot of suppliers defaulted on their payments, actually. And what happened was there was extra storage that was needed, but was not available. As a result of that...
So, for example, people had brought in a bunch of stuff. They didn't move it out into commerce, or they weren't selling it fast enough. They would go out of business. And then these warehouses would just be filled up with stuff that they couldn't get rid of.
That's exactly right. And I cannot get into existing litigation that we have going on now, but we have cases that are lingering from that, where you have suppliers who ordered storage and were not able to pay for it because there was an oversupply of the particular product during the pandemic. And the contractual relationship between the warehouse, the freight forwarder, and the supplier was not very clearly established. There are issues of who owes what, when, where, and that ends up in litigation. And part of the discussion that we're going to have today is how do you avoid that? But to go back to the historical context that we're discussing here, when that shortage of warehousing took place, and we're talking about 2021, 2022, there was an influx of construction of warehousing in the Inland Empire. That resulted in almost unabridged construction. They popped up everywhere, including next to schools, residential areas, hospitals, and other sensitive areas where you wouldn't necessarily want a warehouse to be present next to you.
Yeah, and I think anybody in Southern California that's driven between maybe Rancho Cucamonga and Palm Desert has kind of seen these things pop up.
Absolutely. So they happened so quickly that the California legislature decided that it's going to address what's perceived as that problem and pass, this happened last September of 2024, Assembly Bill 98. And Assembly Bill 98 will take place, it'll come into effect January of next year, of 2026.
So January 1st of 2026.
So it's a very, very quick turnaround, and it affects construction of new warehousing And now we're talking about the big boys, okay? 250,000 square feet or more. And what the California legislature wants to do is generate, or not generate, a better term is facilitate the construction of what they call a 21st century warehouse. And the 21st century warehouse is going to be environmentally green. It's not going to be located next to any schools, next to any residential, within 900 feet and so forth. It mandates the local cities and governments to either rezone or work with the developers and the architects in developing these behemoths. However, it also affects warehouses that are going to want to expand their current capacity beyond 20%. Or if the warehouses are located within 900 feet of these sensitive areas. Again, residential, hospitals, and so forth. So,
is it the idea then being that they want to try to kind of keep all of the warehousing together in a specific area and away from residential neighborhoods, hospitals, schools, those sorts of things, and then control the way that these warehouses are constructed to try to make them as energy efficient or environmentally friendly as possible?
Yes, to all of the above. Yeah,
okay.
Yeah. The restrictions are with respect to road placement, rail connections, and other location-based restrictions like that. It doesn't affect your Costco, warehouse store.
It's going to be like in a commercial center with other stores.
Yeah. So those are actually specifically exempt. But the reason why we're having that discussion about these warehouses.
Yeah, what's the downstream effect or the concern that creates?
So what happened recently here is that half of LA burned down. And what I'm anticipating is a further warehouse shortage because of these restrictions that are put into place. And the demand is going to come into effect in about, I think, a year or two, once the debris from the LA fires is cleared out. And once all of that material starts coming back into California, I think we're going to see...
You mean like the building materials that are going to be shipped in, lumber, shingles, steel, that sort of thing?
All of that, yes. And I think we're going to have a shortage of warehousing again. To a certain degree, the pandemic shortage was never truly addressed. The warehousing that has already been constructed or is in the works, that's not going to be affected by AB98, but it wasn't sufficient to begin with. So now we are facing this shortage that is going to impact owners and I think their ability to move product out of the warehouses.
Yeah, and in the event that so again, it's not, this new bill really isn't going to affect or help necessarily the shortage of warehouse space, and it's still going to present, I think, business for these warehouses moving forward. Is that what you're saying?
That's right. And if you are in the logistics sector, you do not want products to stand still, and you do not want to chase money. You do not want to have your shelves and your square footage filled with material that is not being paid for.
So I think that leads to kind of two questions. One being, what happens if, a warehouseman finds himself in that situation, first of all, and then second of all, like, what can they do to then avoid it?
Absolutely. So we have very, very strong warehouseman's rights here in California, and like most states, actually. If you have ever watched the show Storage Wars, where they cut the bolt and they roll up the door, yeah, and then people make bids on whatever's in there, sight unseen. Basically, what they're doing is enforcing their warehouseman lien, and the warehouseman liens they come into play under Commercial Code 7210. That's how you could perform the warehouseman sale. In order to get there, though, you have to have your ducks in a row, right? You have to have a good warehouse receipt. I think that's step number one. You talk about prevention. Have your warehouse receipts properly drafted, and then follow the statutory requirements for warehouseman lien enforcement under 7210 to the T. And I think that's where a lot of people get tripped up. Either their warehouseman receipts are not clear and they do not provide the checklist that you would expect a warehouseman receipt to have in order to be enforceable, or they don't follow the statutory requirements to get rid of that product and free up their space. So that's where the trip-ups happen. That's where litigation could start. And if you have a litigator who is not experienced in this area of law, litigation could really drag on forever. And at the end of the day, not be very efficient for the warehouseman and the people who are involved in the logistics chain.
Yeah. What are some things that maybe a business owner who is storing in a warehouse, what can they do to maybe avoid some of these pitfalls as well?
The first thing that I think people need to address and think of is that the warehouse receipt is not simply a receipt. It is a document of title. And as a document of title, it becomes a contract. It outlines a contractual relationship between the entity that is storing the goods and the warehouseman. There's really no specific format that the code requires that the warehouse receipt look like. However, there are important provisions that the warehouseman needs to include. And the more specific that the warehouseman is in their receipt, the easier it's going to be to get rid of that product. And what I have seen in my career is sometimes the goods move so quickly and there's such a need to store them that people actually not avoid, but they even miss providing how much the storage fees are going to be. And that becomes a big problem on the back end. And that's just one example.
I.e. the receipts are not specific as to the types of good being stored or how much of them there are?
Correct, yeah. Either the dollar amount is flat out missing, or the idea is let's just store this thing as quickly as possible and however much you have, just bring it in without really quantifying what that amount is. And when you have a relationship that goes sour from there, the question then becomes, well, who really owns this product, right? How much is owed? How much product there is?
And that's all the kind of stuff that litigation is made of, is these ambiguities or the vagueness in these types of documents is what creates disputes and makes it, expensive to litigate or sort it out.
Absolutely. And this is a topic that you and I, Kirk, have had offline, topic of discussion, choice of law. Where are you going to litigate this if something goes south? You have an opportunity as a warehouseman to control that. Are you going to go to court? Are you going to go to arbitration? Are you going to seek mediation? Is that going to be a prerequisite? And those are all topics that each one, I think, could have its own episode on here.
Yeah, we've talked about some of these things, I think, in times past. There's kind of pros and cons to all of those things, right? That need to be discussed or kind of considered in drafting these types of documents, because depending on what a particular warehouseman or business's objectives are or capabilities are, may dictate whether arbitration is more beneficial as opposed to just going through state court or federal court, as it may be, and things like that. And so those are all things that need to be discussed and are things that can be beneficial to go over with counsel ahead of time so that you're not dealing with it on the back end.
Absolutely. And maintenance is cheaper than repair, right? If you're going to be the janitor, it's easier to keep things clean rather than clean them up.
Yeah, I mean, people complain all the time about how much they hate lawyers and how expensive lawyers are, but I think that's because they have typically dealt with lawyers when things are really bad, after a dispute's already broken out, or they've been soured because they've had a family law issue. But I think a lot of the people that you and I have dealt with through our careers that have good lawyers and have dealt with good lawyers and use them as part of their business are able to kind of get out in front of some of these problems before they arise to kind of cut down on the issues.
Yeah, and if you lay a good foundation for what your contractual relationship is, it certainly makes it a lot easier for me, you, and quite frankly, any commercial litigator to come in, look at exactly what the boundaries are of the relationship, and take it from there if need be. And I have a bit of a cheat sheet here with some of the basic provisions that you would expect the warehouseman receipt to have. And some of these are going to sound so silly and so basic, but they're very important and people miss them.
Yeah. So what are some things that people should look out for and make sure that are included?
Absolutely. Start with the name of the owner of the goods. That's as simple as that sounds. If you do not properly identify the particular company that is storing the goods, your enforcement mechanism on the back end is going to become very difficult. Because under the commercial code, you have to provide notice to each and every known owner prior to liquidating the goods. And if you don't get that right down to a T, you're already setting yourself up for an uphill battle.
Yeah.
So something as simple as paying attention to whether you're dealing with the LLC or the Inc. of the particular company makes a big difference. Make sure everything is spelled correctly. Those are very, very simple items to address up front. But if you're looking at the bill of lading that's coming in from the freight forwarder, make sure everything matches up, and you have this chain that goes back to the owner.
All right. What are some other things to keep in mind?
Absolutely. The date of issuance of the receipt, the delivery provisions, the statement of charges. We addressed that. How much are you going to be charging the particular company for the square footage, which includes rate of storage and handling charges. The handling charges a lot of times are excluded, or the warehousemen think that they're being built into the storage charges, but in litigation they become important to separate those out. Description of the goods, or what the packages look like, or their serial numbers, include those. Create a long list of every packet that comes in.
So there's no confusion about what's included as part of what's being stored.
Absolutely, and like I mentioned earlier, if you are feeling rushed and you have orders coming in, and for whatever reason, if you have storage space to fill up, it's very enticing to just say, bring the truckloads, bring them in, we're going to figure it out on the back end. Don't do that. Itemize everything, because once you get to the divorce in the relationship, right? Once you're enforcing your rights, you have to provide proper notice of what goods exactly are going to be sold.
Yeah, and frequently people don't go back and correct things or fix things later because they're already moving on to the next thing as business flows onward. So it's better to do it up front and at the time rather than trying to go back and fix it later.
Absolutely, and that's a very good point. That's a very good point. And I have another check the mark as part of the provisions, and this is another. It sounds so silly, but include signatures. Have a signed document. And we're dealing with a case where the allegation is that the signature was forged, which we could have a whole separate discussion on that topic as well. There's no excuse in this day and age not to have digital signatures. Have a date stamp exactly when it was signed and who signed it, because you don't want to be presented with a situation where you're arguing on the back end, did the particular individual have agency capability to sign something? And believe me, as you know, these things could get costly. Something as simple as a signature could make a huge difference on the back end. So if we're anticipating this shortage of warehousing and we're anticipating the enforcement mechanisms that are going to come in place, go ahead and get your affairs in order now while there is this quiet before, the calm before the storm. Have proper warehousing receipts, have a form ready, and fill it out and do it properly so that when things do go bad, and they inevitably do, you're set for success.
No, those are good recommendations. And I think, those principles apply, beyond just the logistics and warehousing spaces, making sure that all of your ducks are in a row, you're planning ahead, you're looking further out on the horizon to see what problems are coming, because you can prevent problems by making sure you have good processes in place ahead of time, especially if you're anticipating problems coming in the future. So thank you for the insight. This is kind of a niche area of law.
Absolutely.
But I think, it's not just informative for people in the logistics and warehousing spaces, but is going to be helpful for businesses that may use warehousing spaces, or, people that are thinking about how they can better operate their businesses from start to finish. These kind of warehousing issues are going to impact a lot of people, especially in Southern California, because logistics is becoming increasingly important for the operation of all people's businesses. And so I appreciate the time, Vasco.
Absolutely. No, thank you. These principles are very broad. And as you pointed out, they apply to all businesses. Define the contractual relationship properly so that the enforcement mechanism on the back end is a lot simpler, a lot smoother. But thank you so much for having me. It was a pleasure.
Yeah, absolutely. And thank you for joining us on another episode of the LS Carlson Law Podcast.